Johnson.
Brian Bowling on behalf of Mr. Johnson in case ending in 1734, Your Honor.
Yes, Your Honor. Brandon Bird on behalf of Darius Johnson in the case ending in 5312. Mr. Johnson, state your full name for the record.
Darius Johnson.
Judge, we're asking that, my matter and speaking for Mr. Bird, his matter gets set for preliminary examination. I believe discovery to be completed in my case.
Correct, Your Honor. Both matters set for exam, please.
You understand we have a violation?
We do understand it's a violation. At first we thought it was a progress report, not technically a violation, Your Honor.
Because it said progress report at the top or violation? It says violation.
Oh. Well, Your Honor, respectfully, it is a lot going on with my client. He had a medical marijuana card.
Does he have one?
He doesn't. I
just gotta renew it.
This courtroom isn't calm. It's chaotic. A defendant asks for a dismissal. The judge is instantly confused. Attorneys scramble to clarify, and one wrong word nearly derails an entire case. Over the next few minutes, we'll see bond threats, probation violations, emotional defenses, and a powerful reminder that in court, precision matters. Stay locked in, because one misunderstanding here changes everything.
So you don't have one.
Expired. So I technically don't have one.
He doesn't have a medical marijuana. He doesn't have a medical marijuana card.
That's either you do or don't.
I don't.
You don't. Okay.
It expired in 2023. But my client does suffer from PTSD, Your Honor. He went to prison at a young age, at 18 years old. He did 5 years in prison. Self-medicating. It's self-medicating off of that right now. He is taking care of his little brother. His little brother is his dependent that depends on him. Has one child. He has built a successful life for himself with a successful clothing line, but still times is difficult, Your Honor. Taking care of his little brother, taking care of his 3-month son. Went out of town to see his son because he needed to.
Can I chime in? I just got it's no excuse for me not having it. I just got it. Like, you just give me an opportunity to get it, I can have it like tomorrow.
You can have what?
Tomorrow, I can just go online and get it.
And he did come up here. He knew it was going to be a chance.
He was supposed to community correctors told him to discontinue use until he had that medical marijuana card was received and it was approved by the court. But you didn't do that.
Not really.
And that was back in January that they told you that. And you still continued to use.
I did.
All discovery is complete.
In my case, yes, Judge.
In my case, as far as I know, yes, Your Honor.
People, other witnesses available to 17. Preliminary examination in this matter will be set February 17, 2026, 9 a.m. before Judge Moore. At this point, you can't follow instructions and have you out. Bonds revoked. Defendant demanded.
This moment right here is critical. The court made it clear back in January. No medical marijuana card. No use, period. And when the defendant openly admits he continued anyway, that's not just honesty, that's a violation. Courts don't punish intent, they punish actions. PTSD, family responsibility, and hardship may explain behavior, but they don't excuse ignoring direct court instructions. Let me ask you this. Should personal hardship ever override a judge's explicit order?
This case of People versus Thurman Pool.
Your Honor, Raymond Cook.
This is the, what?
26.
26. Morning, Your Honor. Good morning. Saw Mr. Johnson, ready?
No PD assignment?
No, it's not a PD case.
Oh.
It's another bald guy. That's not in uniform. All right. Go ahead, sir.
Good morning, man. Please, this honorable court. Kareem Johnson, on behalf of Mr. Poole, standing in my immediate right.
Chairman Poole, thank you. This is the co-defendant to another case that's coming along. We adjourned the probable cause conference to the 26th. Is that going to work for you guys?
I'll make it work, y'all.
All right. Probable cause conference in this case will be adjourned to February 26, 2026, 9 a.m. Bond at this time will continue.
Thank you, y'all.
Thank you.
Y'all have a good day.
Do the same. Is that it for you?
Yes, sir.
Okay. Court calls the case, People versus Thomas Clemens.
Bird, on behalf of Thomas Clemens. Mr. Clemens, can you please state your full name for the record?
Thomas Allen Clemens.
Thank you, sir. You're asking for an adjournment.
Correct, Your Honor.
Probable cause conference will be adjourned to February 26, 2026, 9 a.m. Bond continue.
Your Honor, respectfully, is there another date that we can do it?
What, you need another date?
No,
Or
no.
you're good?
I'm good.
Okay.
Okay, we good.
All right. Court calls the case, People versus Ernest Gardner.
We're going to Sam Bernstein for Mr. Gardner.
Gardner.
Your Honor, we are asking for an adjournment to review the discovery, and I'm hoping to make a bond argument as well.
Man. I lost my screen. Seeking an adjournment of this matter.
Please, Your Honor.
I will adjourn the matter to the 19th. Probable cause conference will be adjourned February 19th. 2026, 9 a.m. Esteban.
Judge, Mr. Gardner submits that he can be saved community if given a PR bond. He reports to me that he was doing really well before he was arrested. He was working for a program that enabled him to work in exchange for housing, and it was going well. He believes that he can get back in if he's released. He's unable to get back in. He does have a place to stay with his sister, who lives locally in Washtenaw County. He will seek other work. He is motivated to resolve this, Your Honor, and he promises to attend all court dates and follow through with all bond conditions.
Your Honor, we believe that where bond is currently set is appropriate. Most of the situation where, as I recall, we may have been staying at a hotel, and through the course of this, did threaten to kill or send someone, right, to have them kill the officers who were involved and/or their families. We believe this gentleman is
He threatened to kill the officers in the family, his family.
he has all the history of dangerous public.
Anything else?
No, I leave it at.
I'm going to deny the motion for bond reduction. Bond will remain. Right. Thank you.
Yeah.
Case People versus Khalil Taylor. Jeff. Come on.
Last one, Your Honor.
This your last one?
Last one.
Sad.
Yes, Your Honor. Brandon Bird on behalf of Khalil Taylor Jefferson. Mr. Taylor Jefferson, can you please state your full name for the record? Khalil Taylor Jefferson.
What are we doing?
This is where the tone of the courtroom completely shifts. Bond arguments usually focus on stability and compliance, but threats against officers change everything. Even alleged statements like this force judges to prioritize public safety over second chances. Once the court believes someone poses a potential danger, bond leniency disappears fast. This denial isn't emotional, it's procedural, and it shows how quickly freedom can vanish when credibility collapses. Do you think the court made the right call here?
Respectfully, we're gonna waive preliminary examination.
So you're waiving your right to have a preliminary examination?
Yes.
You understand that that's a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination, never been waived. Defendant's bound over to circuit court on a single count.
I'll wait for my reading, stand mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
April 1st at 1:30 with Judge Conlon.
April Fool's Day. April 1st, 2026, 1:30 before Judge Conlon.
Thank you. And you, Your Honor, before have a great day, Your Honor.
You do the same. Always a pleasure. Court calls the case, People versus Mark Carter.
Alan Zend on behalf of the people.
Portion Fisher, Assistant Public Defender on behalf of Mr. Carter, who is approaching the podium. How you doing, sir? State your name for the record, please.
Mark Carter.
Mr. Carter would like this matter set for a preliminary examination, please, Judge.
Discovery is complete.
To my knowledge, Judge.
People have their witnesses available the 17th. Preliminary examination in person, February 17th, 2026, 9 a.m. Before Judge Washington.
Thank you very much, Judge.
Thank you. Bond continued.
Yep.
Court calls the case of versus Deshaun Jones.
Edward Lucas on behalf of Deshaun Jones.
Needs to buy a vowel.
Deshaun Jones.
Thank you.
I'm asking for a little bit more time to negotiate with the prosecutor.
So, probable cause conference will be adjourned to February 26th, 2026, 9 a.m. Bond continued.
Thank you.
All right. Thank you, sir. Oh. I'm just saying. Making a wheel fortune. Court calls the case, People versus Mario Crawford.
Assistant Public Defender Regina Smith and on behalf of Mario Crawford.
Mario Crawford, Your Honor.
Thank you. Court calls the case, People versus Manuel Burnt House.
Good morning, Your Honor. Veronica Glenn requesting permission to practice pursuant to Michigan Court Rule 8.120.
Oh my God. What?
Under this.
No, we'll wait.
Do I need to start over?
What? Do you need to start over? What? You seem flustered.
No, I'm fine.
No? Okay. Go ahead. Take a deep breath. We can get through this.
Okay. Good morning, Your Honor. Veronica Glenn requesting permission to practice pursuant to Michigan Court Rule pursuant to 8.120 under the supervision of Assistant Public Defender Attorney Stephanie Cannon.
And then some days it just doesn't happen, right?
Exactly.
You said it like a million times. I don't know why. It just wouldn't.
I don't,
Permission to practice is granted.
thank you, Your Honor. In this matter, we have received additional discovery that we need time to go over with our client. So we would like to adjourn it.
Your Honor, there also will be a.
Is he in Zoom? Oh, sir. Can you unmute and state your name?
Here, Your Honor, Manuel Barnhouse.
Thank you. Is that Lebo? Was that yours?
Father? You're not Mr. Your Honor.
What are you asking to do?
Your Honor, can we approach real quick?
Sure. Okay, record should reflect we've had a brief bench conference in this case. That objection, probable cause conference will be adjourned to March 12th, 2026,
Thank you.
9 a.m. Bond will continue. Thank you.
Thank you, Your Honor.
That was called the case, People versus Michael Furnace.
Morning, Your Honor, Raymond Cook and people.
The judge, portion of fees to assistant public defender on behalf of the defendant who is approaching. Please state your name for the record, sir. Thank you, Judge. I did meet with my client. We are still in the process of trying to work through this matter. There should be a green sheet in the file. I'll be requesting a brief adjournment.
Is there anything?
I believe so, Judge.
Probable cause conference will be adjourned then to February 19th,
Thank you, Judge.
2026, 9 a.m. Bond continue.
I'll be working on video with you.
Calls case, People versus Stacy Troon.
Alex Jawlowski for people.
Yep.
Bernstein for Ms. Trun, Your Honor.
Advice of rights or whatnot.
No, Your Honor, we went over that with her, but because she's in Gratiot County, we couldn't obtain it.
You didn't get her permission to sign one.
No, I do have her permission to sign, I guess. I
And
just-
I'll need that permission. All right. I have a plea sheet before me indicates that the defendant is going to be pleading guilty to the charge of use of cocaine. That's a 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement. Is that correct, counsel?
Yes.
Yes, Your Honor.
All right. Ms. Troon, can you raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right. State your name again for the record.
Stacy Truin.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of use of cocaine. That is a misdemeanor, punishable by up to 1 year incarceration and $1,000 fine plus court cost. Do you understand that?
Yes.
You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Garwood in the 15th District Court. You understand that?
Yes, Your Honor.
All right. You still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You went through an advice of rights and gave your attorney permission to sign one on your behalf. Is that correct?
Yes, sir.
Do you have any questions regarding any of those rights?
No.
And you understand that you're waiving or giving up all of those rights, including the rights contained in paragraph 5, your trial rights.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
I wasn't at the time of the incident. I'm on probation
Okay.
now from Gratiot County.
Okay, but you weren't on at the time of this offense.
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Has anybody threatened you or coerced you in anything?
No.
Do You're doing this voluntarily
Yes, sir.
of your own free will,
Yes.
and also because you believe that you're guilty of this offense?
Yes, sir.
September 22nd, 2025, at the location of 100 South 4th Street, City of Ann Arbor, Washtenaw County, State of Michigan, did you have cocaine in your possession?
Yes, sir. I was using cocaine.
And you used it?
Yes, sir, I did.
And you knew what you were using was cocaine?
Yes, sir.
All right. Ma'am, if I accept your plea, between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rule, you would not be able to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No.
No, Your Honor.
And have I complied with the court?
Yes.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
March 3rd at 9 a.m. Judge Garwood.
March 3rd, 2026, 9 a.m. before Judge Garwood. Bond will continue. Thank you, Mr. Tran.
Thank you.
Court calls case People versus Omar Mims.
Andrew Phillips, on behalf of the people.
That you're guilty of this offense?
Yes, sir.
September 22nd, 2025, at the location of 100 South 4th Street, City of Ann Arbor, Washtenaw County, State of Michigan. Did you have cocaine in your possession?
Yes, sir. I was using cocaine.
And you used it?
Yes, sir, I did.
And you knew what you were using was cocaine?
Yes, sir.
All right. Ma'am, if I accept your plea, between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rule, you would not be able to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No.
No, Your Honor.
And have I complied with the court?
Yes.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
March 3rd at 9 a.m. Judge Garwood.
March 3rd, 2026, 9 a.m. before Judge Garwood. Bond will continue. Thank you, Mr. Tran.
Thank you.
Court calls case People versus Omar Mims.
Andrew Phillips, on behalf of the people.
I know. This is Public Defender J. Bellinger on behalf of Mr. Mims, who approaches, Your Honor. Mr. Mims, can you please state your name for the record?
Omar Mills.
And Your Honor, we do have an offer upon a waiver in this case, so we do intend to waive today. I'll let Mr. Jill just put the offer on the record if he's comfortable.
That's fine. The offer would be typically to one count of resisting obstructing the other. Dismissed.
All right. So you're waiving your right to have a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and the offenses alleged were committed and that you committed them?
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
All right. People also waive their right.
Yes, sir.
Preliminary examination, having been waived, defendants brought over to circuit court on both counts.
Your Honor, we would stand mute at this time, wait formal reading, and we acknowledge receipt of the information.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial in this matter will be set for
February 17th at 1:30 with Judge Constable.
February 17th, 2026, 1:30 before Judge Combs.
Okay. Thank you very much.
Thank you. Bond will continue. Thank you. Court calls the case People versus Walter Peterson.
You're making cook for the people.
Good morning, Your Honor. Robert Ellman on behalf of Mr. Peterson on both matters. I believe he is in custody on Zoom here.
Mr. Peterson, can you state your name?
Mr. Peterson.
Thank you.
Your Honor, the Public Defender's Office has recently discovered a conflict on the retail fraud case, so I'm newly appointed to that one. I am working with the people towards a global resolution of all of Mr. Peterson's matters. I'd be asking for an adjournment so that we could have some additional time to work that out.
Are these the only things holding him, or is he held on something else?
Your Honor, we had a matter yesterday.
Yes, we did.
Well, let's see how many cases he currently has in just a second. I'm seeing it looks like there's 4 open cases as well as 2 more still to be charged.
Got it. Probable cause conference, February 26, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
And that's it for me, Your Honor. Have a good day.
All right, you didn't say, Mr. Ellman.
Thank you.
Court calls the case, People versus Kristen Shukai Capehart.
Good morning, Your Honor. Raymond Cook with the people.
I know.
Good morning, Your Honor. Blood Center Doppy Lee on behalf of Mr. Shukai Capehart. Mr. Shukai Capehart, could you give the court your name, please?
Christian Shukai Capehart.
Thank you.
And Your Honor, would like to set this matter for preliminary examination, please, as well as address bond.
Discovery is complete.
It is, Your Honor.
People have their witnesses available the 17th.
Do our best, Your Honor.
Preliminary examination in person, February 17th, 2026, 9 a.m. before Judge
Moore.
Judge Moore.
And Your Honor, with regard to bond, Mr. Shukai Capehart has learned his lesson from the past week in jail. He does tell me he has a phone in his property now that will be working. I provided him with my direct number. He understands that if he's released, he must go directly to community corrections upon release. I don't believe there will be any more bond violations in this matter.
But they had been trying to contact him.
Yes, Your Honor.
He didn't go over after he didn't follow the instructions.
Your Honor, they were not able to reach him. He does now have a working phone in his property, and he certainly understands.
It was not working before, but now it is.
Apparently, he did not have a phone at all before because it had been stolen, and now one's been dropped off to him. And he certainly understands that if there are any violations in the future, he'll go right back to jail.
Any response from the people?
No, Your Honor.
I'm not at this point going to change his bond. He should have followed the instructions. He could figure out how to do that, or at least get in contact with him, and he didn't do it. Bond will continue as set. Thank you. Court calls case People versus Ashana Barrett.
And on behalf of people.
Barrett, right, Judge? Attorney Feaster, Assistant Public Defender on behalf of Ms. Barrett, who does not appear. Oh, there she is. Thank you. Please state your name for the record.
She's right there.
I saw her the whole.
Why were you going to say she wasn't here? I saw her.
Ms. Barrett, please state your name.
So he knows who you are. Thank you, ma'am.
Thank you, Judge. We'll be requesting a brief adjournment so that Ms. Barrett and I can talk and negotiate with the prosecutor further, Judge.
Full cause conference will be adjourned February 26, 2026, 9 a.m. Bond will continue.
Thank you, Judge.
Oh, everything. I'm out of custody. Still have to make more in custody.
I believe that is not what I said.
I didn't understand what you were trying to tell me. Court does call the case. Other people versus Bridget Beck. Are we better now?
Yes.
Okay.
Veronica Glenn on behalf of Ms. Beck.
Courtroom.
I don't see her. Is she on Zoom? I didn't see her up there. Is she on Zoom?
No. I don't see her.
Okay, can we have an adjournment in this matter? We have not
It's like
received
you're
it.
being a puppet or a kid, one of those little birds, a minor bird.
Okay, say what you know.
No, I'll wait.
Okay, sorry, Your Honor. We like to request an adjournment in this matter because we do not have discovery. And if we're unable to obtain this discovery, we would like to request a dismissal.
You like to what?
Request a dismissal.
Did she tell you to say that? No, don't. Did she?
Your Honor, I'm
There's gonna
sorry.
be a fight.
So the thing that's happened here, we spoke with Ms. Stephanie Cannon on behalf of Ms. Beck. What we did was we spoke with Ms. Beck and we let her know that because we don't have discovery, we would likely be requesting an adjournment because we don't believe we're going to get a dismissal. I believe she just got confused by those statements. She has appeared by Zoom for everything. She's not missed a date. This case is from 2009, I believe. She's not had any new charges. I believe she just misunderstood when we told her what we were ultimately asking for in this matter. Your Honor. So we're requesting an
Did you
adjournment.
tell her not to be here?
What we told her that if the discovery wasn't present, we were going to ask for dismissal. I believe she just interpreted that to mean that because we told her we still don't have discovery, that we were just going to get a dismissal. So no, we did not tell her that, Your Honor. I believe she just misinterpreted what we were saying. We can see if we can get her here by Zoom if you want to move it to the back end. So many could.
You want me to like pass it so you can get her on Zoom?
Please. Please.
For you? No. Miss Glenn, are you asking for that?
Please, yes.
I'll do it for you.
Thank you.
We'll just put this into the next block, see how much confusion there has been.
Thank you.
Because it's just.
The woman steps forward, clearly nervous and confused. She looks at the judge and says, "I didn't receive discovery, so this case should be dismissed." The courtroom pauses. Then her attorney quickly stands up. "Your Honor, I'm sorry. She's confused." The attorney explains calmly. Discovery has not yet been requested. The judge nods. The misunderstanding cleared instantly. The tension fades, but the moment hits hard. In court, words matter, and confusion doesn't erase the process. This isn't dismissal. It's a lesson learned in real time.
Anybody talking to Cannon gets confused. So I get it. Court.
This is a investigation request for travel. The next one about to call.
This is pretty fancy. I'm not gonna let it happen. Court calls the case, people versus Carla Bourdon.
Sorry to slow you down.
That's because I know he did it. That's why it's fancy. Everything he does is fancy.
I don't know about that, but thank you, Judge. Brian Bowling on behalf of Ms. Bourdon.
Your name?
Carla Bourdon.
Judge, we're asking this matter be set for a preliminary examination.
Your Honor, there is a co-defendant in this case. My understanding is they're going to be requesting the same thing. I don't.
Mr. Killawald represents the co-defendant. I think that's set in the 12:30 block, Your Honor.
That's correct. Would it be possible if we set this out just a little bit farther? I feel like that's our best chance that Mr. Killawald will be available on the, instead of setting out 17th.
Right. He's, as I'm recalling, not that I specifically recall his schedule, I don't think he's going to be available that day.
Perfect.
You wouldn't have any.
If I got him right. I get him and Goldstein mixed up.
The whole scene's just gone for like.
Yeah, it goes, right. And I'll try to get some flexibility on this. Okay. I thought he was available the 24th. I thought I said.
I could try and call
Um. Want me to pass it. Cannon wants me to pass it. This is just getting hard.
We're fine with whatever.
Let me pass it. That way we can get a date certain set for you, okay? So I'll pass it. Fine.
Sounds good.
Thank you.
Or we could just wait till Mr. Killawall gets here at 12:30. We could excuse her and pick a date.
Let's see. That was so eloquently stated, wasn't it? Almost to the point where I might do that. But if I start that precedence, the rest of them are going to ask, but they won't have everything in order, right? Bowling, I know, has it all together.
Sometimes, Judge. Thank you, though.
Okay. Ma'am, keep in touch with your counsel. We'll be setting it. They'll give you the date that your prelim is set once Mr. Killawall gets here, because that'd be a wild ride.
That's fine.
There is only one other thing in here we just received, I think. Travel request.
Yes, Judge. She's asking to go to Toledo, Ohio specifically.
Why?
For a job interview, Judge.
In Ohio?
Yes.
Yeah.
Do they have jobs? They do? Okay, go ahead. I'm sorry.
She'll just go to work and then come immediately back, Your Honor.
She will?
Yeah. And that's same for the job interview. She's going to go on the 12th and then come back that day.
Closing the border.
Oh.
I don't think that.
Why not everybody else?
What happened?
I didn't say that. I did?
Mhm.
Oh, sorry, my bad. I'll just be quiet and sign off on this.
Thank you.
All right. Good luck in Ohio.
Thank you.
All right.
I'll give you a call.
We're gonna recall this with code.
He's good on that.
He is? Hold on.
Well, I didn't hear what was
Taking
said.
way too long.
Texted Mr. Killawall.
Oh, all right.
So. Preliminary examination in person will be set for March or February 24th before me. 9 a.m. All right. Thank you.
Thank you, Judge.
Courthouse case, People versus Jessica Frescala.
Andrew told us to bring on behalf of the people.
Brian Bowling on behalf of Ms. Brasgala. Does not appear to be here, Judge.
Frescala. Not present.
I will just state for the record, I was unable to get in touch with her before today's hearing.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000. Cash surety. That warrant will issue immediately.
Thank you.
Court calls case of the People versus Devon Brown.
Morning, Your Honor, Raymond Cook.
I'm here.
Man, it's your case.
This is Devon Brown.
Yeah, I know.
Oh,
We're
sorry.
waiting for your attorney.
Apologies. Assistant Public Defender Davi Lebo for Mr. Brown. And Your Honor, we're going to be requesting adjournment in order to receive an offer.
Cause conference will be adjourned to February 26, 2026, 9 a.m.
Thank you, Your Honor.
Court calls case People versus Tyler. Is it Cartagena?
And Assistant Public Defender Jay Bellinger on behalf of Mr. Cartagena. I might be mispronouncing that too, but can you state your name for the record?
Cartagena.
Cartagena. Thank you. And Your Honor, we are just asking for an adjournment today. We just got better communication with our client. And we are just wanting to go over some discovery with them.
Probable cause conference in this matter will be adjourned to February 26, 2026 at 9.
Thank you very much. Put that on your phone, okay?
All right. Bond continued. Thank you.
February 26th at 9 a.m. Okay.
Court calls the case of the People versus Monica Collis.
With the people.
Ready-ish, Judge.
Ready-ish?
Yes, Judge. Torshio Feaster, Assistant Public Defender, appearing on behalf of, but I do not believe with, Monica Collins. Your Honor, we did reach out to Ms. Collins by phone, email, and text. We did not reach her. For the record, I will be requesting an adjournment, but I do not know where Ms. Collins is.
Bench warrant will issue for defendant failure to appear. Bonds will be set in the amount of $10,000 cashier.
Thank you, Judge.
And the bonds will check as well. Continue. Court calls the case of the People versus Zakara Daphne Urciaga.
Brian Bowling on behalf of Ms. Daphne Bursiaga, Your Honor. State your name for the record, please.
Zakara Daphne Bursiaga.
Judge, I'm asking for an adjournment. Mr. Chabalowski and I have reached an agreement in this case. There's just a couple of collateral issues that I would like to look at before allowing my client to move forward with the plea, which she does intend to do. But I just want to confirm a couple of things. So if we could get a
understood. Why don't I adjourn it to February 5th? Or I'm sorry, March 5th.
Okay.
2026, 9 a.m. Bond will continue.
Today's docket shows exactly how fragile court proceedings can be. From misunderstandings about discovery to probation violations, bond denials, plea agreements, and bench warrants. Every outcome hinged on preparation, communication, and compliance. Judges consistently reinforced one message: responsibility matters more than excuses. Some defendants moved forward cleanly. Others faced serious consequences for confusion or non-appearance. If you found this courtroom breakdown as eye-opening as we did, hit that like button, share your thoughts in the comments, and subscribe for more real, unfiltered courtroom moments and expert legal breakdowns you won't see anywhere else.